whether you wear a badge or not. If you care about courage, clarity, discipline, and the price of decisions in the moment that define lives, you've come to the right place. This is where training meets consequence, where the law collides with human behavior, and the fog of uncertainty tests the limits of reason. These are the stories of pressure, of purpose, and what it means to hold the line when the world loses balance. I'm Don, a police officer, instructor, and founder of Forecast Securities Group, and I'll be your guide through the storm. Welcome to the Conditions Report. Hello, welcome back. This is going to be episode 22, Digital Dragnet. I'm Don, and this is the Conditions Report. If you've already been listening to the show, you know the premise. And if you're new here, well, here's what you need to know. This is the weather forecast for street cops, detectives, and admin, what's coming, what's changing in the environment that we work in. Before we go any further, you already know, a quick disclaimer. I'm not an attorney, and nothing discussed on this show is legal advice. I'm not speaking on behalf of any government agency or law enforcement agency, and the views expressed here are those of Forecast Securities Group, and they're an exercise of protected American free speech. If you need legal advice or guidance specific to your agency or jurisdiction, you should consult a qualified legal attorney. This podcast is for educational and informational purposes only, and we're not here to judge the officers involved in the incidences or second-guess the decisions with the benefit of hindsight. The point is to learn from their hard-earned lessons on our behalf. We're going to examine Chatrie v. United States, which is now pending before the Supreme Court after it was granted certiorari review on January 16th, 2026. Limited to the question of whether the execution of a Geofence warrant violated the Fourth Amendment. And this case arose from a 2019 armed bank robbery investigation in Virginia, where Chesterfield County and federal investigators obtained a warrant directing Google to search its location history data for devices present within a 150-meter radius of a credit union during a 1-hour window. The three-step process first produced anonymized identifiers and then expanded location data, and finally subscriber information that identified the petitioner, Okello Chatrie, leading to his conviction. For detectives and investigators, this ruling will clarify when digital location tools can be used without risking suppression of critical evidence in cases lacking traditional leads. Administrators face decisions on training affidavits for particularity and probable cause to withstand appellate review, and the constitutional stakes center on whether geofence warrants satisfy the particularity and probable cause requirements that have protected liberty since the founding, ensuring technology serves justice rather than inverting the balance between authority and privacy. Situation brief. On the afternoon of May 20, 2019, in the suburban community of Midlothian, Virginia, I don't know if I'm saying that right, just south of Richmond, the Call Federal Credit Union branch was conducting routine business when an armed robber entered shortly before 4 o'clock. He wore a black jacket, gloves, and a ski mask that fully concealed his face. Witnesses later described him as calm but authoritative, brandishing a handgun and ordering the small group of employees and customers to the floor. He directed one teller to open the vault and methodically loaded approximately $195,000 into a bag. The entire episode lasted under 10 minutes, with no shots fired and no physical injuries, though the terror left a lasting impression on those present. He exited calmly and drove away in a dark sedan, disappearing into the surrounding residential and commercial area before officers arrived. Chesterfield County Police responded within minutes, and they secured the scene and began collecting statements and surveillance footage. The bank's interior cameras captured clear images of the masked suspect's movements through the lobby and into the secure vault area, but offered no view of his face, license plate, or unique identifiers of the vehicle. An initial neighborhood canvass produced no useful sightings, and the vehicle description matched hundreds in the region. Fingerprints recovered at the scene proved to be inconclusive because of the gloves. And detectives reviewed the video repeatedly, noting the suspect's approximate height of 5 feet 10 inches and an average build. Yet these details were far too generic to generate immediate suspects. The FBI assumed primary jurisdiction given the federal insurance on the credit union, and the investigation expanded without a clear suspect profile. And you know how it is in those early days when every single traditional avenue seems to close all at once. With conventional leads exhausted, after several days, the team pursued digital forensics. They prepared an affidavit detailing the robbery's precise time, location, and manner, and sought a geofence warrant from a federal magistrate judge. The warrant authorized Google to search its location history database, which aggregates GPS, Wi Fi, Bluetooth, and cell site data from users who had enabled this feature. The geographic scope covered a 150-meter radius around the credit union, roughly 17 acres that included nearby homes, a church, and businesses, limited temporarily to a 1-hour window encompassing the crime. The magistrate found probable cause that evidence related to the robbery would be located in Google's records and approved the warrant. Google responded with a now familiar 3-step process. Step 1, they returned 19 anonymized device identifiers that had been inside the geofence during the relevant hour. Detectives reviewed movement patterns, eliminating those consistent with employees or stationary bystanders. 9 devices showed activity more aligned with suspects' quick entry and exit. In step 2, the government requested expanded location history for those devices, covering 30 minutes before and after the initial window, revealing a broader travel route. One device stood out for circling the bank beforehand, remaining during the robbery window, and then departing immediately afterwards. Step 3 sought subscriber information for 3 devices, including the one that matched this pattern. Google provided the account details that tied Okello Chatrie, a local resident with a prior nonviolent record. Traditional warrants then followed for his residence and phone, recovering matching clothing, gloves, and a handgun. Cell site records corroborated the geofence data, and Chatrie was arrested in June of 2019 and charged with the Hobbs Act robbery and brandishing a firearm during the crime of violence. At the suppression hearing in the Eastern District of Virginia, the defense challenged the geofence warrant for lacking particularized probable cause and particularity, arguing it swept up dozens of innocent users without individualized suspicion. The district court agreed the warrant failed those requirements, but applied the good faith exception under the United States v. Leon, finding officers reasonably relied on the magistrate's approval. After trial in 2022, a jury convicted Chatrie on both counts, and he received a 12-year sentence. He appealed to the Fourth Circuit, which, sitting in banc, issued a 1-sentence per curiam opinion, affirming the conviction while producing 9 separate concurring and dissenting opinions totaling more than 100 pages that reflected deep division over privacy expectations in short-term location data and the adequacy of the narrowing steps. The Supreme Court granted certiorari on January 16, 2026, limited to specifically whether the execution of a geofence warrant violates the Fourth Amendment, with the argument scheduled for April 27, 2026. As the case proceeds, every detective who has used or considered geofence data in a suspect-less investigation is watching closely, myself included. The current conditions are this. The constitutional analysis under Chatrie v. United States centers on the Fourth Amendment's command that no warrant shall be issued but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The warrant here directed Google to search its location history database for every device present in the defined geographic and temporal area, and then disclose narrowing information through 3 iterative steps. Chatrie argues that this process constituted an unreasonable search because it lacked individualized probable cause for each of the users swept into the Dragnet and failed the particularity requirement. The government counters that the warrant was supported by probable cause, that the evidence of the robbery existed in the database, and that the multi-step narrowing provided sufficient safeguards. It is the kind of moment that makes you pause in the briefing room and wonder how the rules that we learned on the street still hold when the evidence lives in a server farm far away instead of a file folder. The governing framework begins with Carpenter v. United States, which was decided in 2018. There, the court held that the government's acquisition of 7 days of historical cell site location information from a wireless carrier was a search requiring a warrant. Chief Justice Roberts explained that individuals maintain a reasonable expectation of privacy in the whole of their physical movements because such data reveals the privacies of life, including familia, political and professional, religious, and sexual association. Sometimes we like to call this pattern of life. The ruling distinguished earlier cases like United States v. Knotts, where a single trip tracked by a beeper was not a search because it replicated visual surveillance possible with the naked eye. Carpenter emphasized that retrospective digital tracking is qualitatively different, allowing authorities to travel back in time and reconstruct movements in a way unimaginable before modern technology. The court warned that without warrant protections, society's expectation that law enforcement could not securely catalog every movement would be upended. United States v. Jones, decided in 2012, supplies additional guidance. Officers in this case attached a GPS device to a vehicle and tracked it for 28 days. The court held this as a search, with Justice Alito's concurrence, stressing that prolonged surveillance, once impractical and costly, now invades reasonable privacy expectations. Justice Sotomayor added that such monitoring chills associational and expressive freedoms. These principles apply to geofence warrants because they permit retrospective reconstruction of movements from a third-party database without prior suspicion of individuals whose data it collected. The district court in these cases applied Carpenter directly. It recognized that location history data generated from multiple sensors and stored by Google reveals far more intimate details than a traditional surveillance. The court found that the warrant lacked particularized probable cause as to every device in the 150-meter radius, citing Ybarra v. Illinois, where the Supreme Court suppressed evidence from a pat-down of a tavern patron because a mere proximity to a suspected criminal activity did not justify searching everyone present. The district court analogized the geofence to a digital dragnet that treated innocent bystanders as potential suspects solely because their phone was nearby. Nevertheless, it declined to suppress under the good faith exception of the United States v. Leon, where officers relied on a later invalidated warrant in objectively reasonable fashion. The court noted the novelty of the tool and the officers' consultation with prosecutors supported a reasonable reliance. The Fourth Circuit, sitting in banc, affirmed in per curiam opinion while issuing multiple separate writings that explore whether short-term location data triggers Carpenter's protections and whether the three-step process cured particularity defects and whether anonymization sufficiently protected privacy. One concurrence emphasized that limited 2-hour scope and narrowing steps distinguished the warrant from the longer-term tracking in Carpenter. Dissents warned that initial steps, 1, search millions of users without individualized suspicion, resembled the general warrants in the framers' rejection. The constitutional principle reaffirmed by whatever ruling the Supreme Court ultimately issues will be that digital investigative tools must still satisfy Fourth Amendment demands of probable cause, tied to a specific individual and a particular description of the evidence sought, preventing technology from authorizing the very broad sweeps the amendment was written to forbid. That brings us to the leadership navigational aid. The advancements of the arts from year to year taxes our credulity, and it seems to presage the arrival of the period when human improvement must end. Henry L. Ellsworth, the first commissioner of patents, offered that reflection in 1843 as he marveled at the pace of innovation. His words illuminate the single leadership principle this case demands of every single commander and supervisor. Exercise disciplined restraint when adopting powerful new investigative technologies so that efficiency never outruns the constitutional safeguards. In Chatrie, the officers faced a stalled robbery investigation and turned to a geofence warrant that ultimately identified the perpetrator. Yet the courts are divided sharply over whether the initial sweep satisfied particularity and probable cause. Leaders must therefore insist that affidavits articulate why they chose the radius, the time frame, and the narrowing steps are the least intrusive means available, documenting alternatives considered and rejected. This principle flows directly from the facts, where a 17-acre digital dragnet captured churchgoers, residents, and passerbys before any individualized suspicion was attached. I have watched good leaders navigate this exact tension time and time again, and it always comes down to the same choice. When officers raise internal concerns about the breadth of such a tool, leaders should welcome the dialogue. Garcetti v. Caballeros reminds us that speech made pursuant to official duties belongs to the employer, yet wise commanders still create a space for constructive critique of the investigative methods without fear of reprisal, ensuring practices evolve within the constitutional bounds. The same discipline restraint applies when reviewing geofence requests from subordinate detectives, requiring supervisors to verify that a warrant application meets the heightened standard now up for review by the Supreme Court. Rather than rubber stamp a novel request simply because the technology is available, ultimately leaders carry the full weight and responsibility. Alexander Hamilton warned about when he observed power that can sometimes wear the mask of public good. In the digital age, the mask is especially seductive because the tool promises a quick result in a difficult case. And the duty of a command is to lift the mask, insist on precision, and model the Constitution's discipline that protects both effective policing and the liberties that we're sworn to defend. The extended forecast is this. Looking ahead, geofence warrants and similar reverse search tools will remain part of the investigative toolkit as agencies continue to confront crimes with vanishing physical evidence. The Supreme Court's forthcoming decision may impose stricter requirements for affidavits to demonstrate why a particular radius and duration minimize intrusion on non-suspects, potentially requiring real-time judicial oversight at each narrowing step, or maybe even enhanced documentation of false positive risks. Technology companies are now already shifting location history to on-device storage, which may force investigators towards alternative providers or compel legislative updates to warrant statutes. And public scrutiny and institutional pressure from privacy advocates will likely accelerate agency policies requiring supervisory approval and audit trails for every geofence application. While evolving doctrine could extend Carpenter's logic to the aggregate data sets. As we look ahead, I suspect we all will be adjusting our practices together. Leaders should respond by embedding scenario-based training that walks officers through affidavit drafting, particular analysis, and suppression hearing preparation. Patrol supervisors and detectives alike must cultivate the habit of asking whether less intrusive methods exist before requesting digital dragnets. Constitutional discipline, careful judgment, and evidence-based precision will remain the steady compass, keeping operations on the right side of the line between necessary authority and unwarranted surveillance, even as tools grow more sophisticated. As we close, let's remember the point of the show is not to pass judgment or to revisit the decisions with the benefit of hindsight. It's to learn as a team and improve. We're all leaders, so keep the L&A in the back of your mind. The work is very complicated, the environment is demanding, and none of us get it perfect. So stay hungry, stay humble. I'm Don, and this has been the Conditions Report. Be the calm in the storm, the clarity in confusion, and always influence the weather.